मतलब वो चल नहीं पाती है, उनको बार बार हॉस्पिटल में एडमिट होना पड़ता है, उनका फूड पाइप आर्टिफिशियल लगाया गया है, वो खा नहीं पाती हैं।
ऐसे इंस्टेंस कोई हुए हैं?
सर हमारे पास बहुत सारे इंसिडेंट हैं ऐसे, सच सर्वाइवर्स विद
Lord, I have on my request, she has shared the copy, my lord, with me. Lord, this I don't think any respondent can oppose.
Nobody will oppose it.
It has to be, my lord, treated as disabled for the purpose of, my lord, I'm not, my lord, saying in a pejorative term, my lord, sense, but under this act, my lord, they will have to be covered, my lord.
Mr. Solicitor, do one thing. One, that if at all any that definition requires any clarification, of course we can do on judicial
The
side.
lordships can interpret, otherwise I'll see that it is amended.
But if there is affirmative action from your side, one small explanation, ordinance can be issued.
Yes.
That will be. And secondly, please also consider, today we will not pass anywhere, we will leave to you to consider. All these cases should also be tried by special courts.
Yes, my lord, on a day-to-day basis, no adjournment.
We will on judicial side fix the timeline. We will direct the high courts to fix special courts. You also notify them.
Yes.
And why this is mockery of the system?
Lord, the accused must meet with the same ruthlessness.
Absolutely.
With which he has committed this offense.
Absolutely. These persons must not be, no court must have even sympathy of any kind of court.
Lord, I bow down.
The entire system must respond against them. You please bring those details on record. Say issue notice. Learned Solicitor General of India, who is present in court, has graciously accepted the notice. He has also expressed concern about the causes raised in the instant petition. Post the matter for further consideration.
Next week, my lords. You may have to join state of.
While we direct the Registrar Generals of all the High Courts to furnish the details of pending trials in the cases of acid attack victims. All details of all the pending trials in their respective jurisdiction of the in the matters of acid attack victims. Let us get the details also.
Yes,
the trials pending.
that might take a little while, but for considering this, my lord, have it on the.
That's right.
Yes.
For say post the matter on so and so date for to enable the learned solicitor to have instructions meanwhile, and then issue notice to the registrar generals, all the high courts through registrar generals for so and so date. That will be after 4 weeks in January.
She may. I'm told, my lord, the trial is the incident is of that of Haryana, of my sister, my lord.
Delhi.
So state may have to be implemented. That may be the.
This is a public interest litigation on a different topic.
No. The honorable court is suggesting.
No,
in your
trial is
case,
pending in Haryana or in Delhi?
In Delhi. She had
Transferred to Haryana, from Haryana to Rohini.
Transferred from Haryana to here.
to Delhi, but possibly the prosecuting agency.
After transfer, Mr. Solicitor General, in all probability, the Delhi administration.
Whoever is the
Delhi administration.
prosecuting agency, kindly join with a prayer, amendment prayer.
Or you file simple application. Learned solicitor is advising you, just file an application about her trial also.
Sure.
We would like to see that it is expedited.
Deeply obliged.
Obliged to. Lord, 16, my lord, we are all PSUs, Lord, employ, but this is 2-year contractual period. Lord, if we invite applications, it would be, my lord, in thousands. For example, in my lord, Delhi post, my lord, PP post, we received 5,000 plus. Interviews are still going on. So what we do is a rational formula, according to me, that we go by the score in CLAT PG. So they are all law graduates, and
They are engaged for the purpose of defending the cases as advocates, or
no, they would be our law officers.
your law office.
Law officers.
So they will be working in the establishment for legal.
As 2 years contractual period as law officers. The nomenclature may be different. Young professional legal.
इधर आ जाइए इधर। Just to Lordship,
Only one fact I must additionally. Lord, Kerala High Court faced the similar issue in case of NTPC, my lord. And there is a division bench judgment of Kerala High Court accepting our stand, against which SLP
No,
filed, there is no stay.
We have seen in the engineering services, based upon gate examination, people are selected.
Yes.
the position is this, not your Lordship, may kindly see.
And
That-
this is only engagement for 1 year, 2 years.
Engagement for 2 years, naturally, my lord. And the law graduates who they are practicing in various courts, either district courts or high court or anywhere, they are competent enough for all these purposes. That's why Lordship may kindly
It is
come.
for a client to engage. By the way, if you apply the Sri Lekha Vidyarthi principles right from the onward,
that-
can we,
that-
going by simple principle, can we force a client that you must engage a particular type of concept?
When we engage a
not
law
like that.
graduate,
Just-
when we engage a law graduate as a civil judge junior division, don't we take a entrance test?
So far,
So if the entrance
Your
test
Lordship
is outsourced,
I bow down,
as
your
a
Lord.
CLAT examination,
I bow
what
down,
is
your
wrong?
Lordship is right. But so far as where some expertise in obtaining greater knowledge is concerned, here the matter is quite different. Here the matter is of contractual obligations and other things.
That
That's
is
why,
for the employer
that's why
to see.
law
That's the
graduates who they are
employer's
practicing are
Employer
sufficient
to
enough.
Employers prerogative. Issue
And
notice,
it is not a case of outsourcing, Lord.
returnable and so on, so dates, then
SLP is there, I think Kerala High Court raised.
Yes, my lord. Kerala High Court has held in my favor. Similar,
but that SLP has come.
There is an
SLP is
SLP.
there, my lord. There is no stay. SLP number.
Pending a selfie, Lord, that is only thing. Here you would say mechanically.
Issue notice.
But I had appeared, therefore I am aware, my lord, it's the same question.
Who will accept notice on behalf? Who is Shanu Baghel? Then so and so accepts notice.
Practicing
on behalf
advocate
of-
in Delhi High Court, Lord.
Response number 1, contesting response number 1. Tagged with SLP number, SLP civil diary number 34962/2022. Meanwhile, operation of the impugned judgment of the High Court, Delhi High Court, dated 24 September 2025 shall remain stayed.
Grateful to.
Lord, just Lordship has stated, Lord. My submission is, Lordship, may kindly see, this is a matter, my Lord, and there should be an adequate opportunity for all the purposes. Now, the whole position, this public interest litigation was filed, is seeking in mind two things, my Lord.
Sir, when they have a transparent, uniform criteria, non-discriminatory criteria of shortlisting young law graduates only for the purpose of working on the establishment for 2 years.
Just so far CLAT part is concerned, I want to express my opinion that in Banaras Hindu University, other central universities, a different type of classification has been fixed for getting promotional studies. But here CLAT 2 is only for exceptional purposes where most advanced studies for research work is there. It is, but if National Highway Authority of India is engaging an advocate, a person from law designation,
Officer,
a person from other purposes, that is an expertise opinion that can be obtained through
Can
the
you
advocate
prevent
only.
them? Can you prevent them? They will say, well,
No, I can't.
No, we are asking because you will guide us. Can we prevent them from engaging any private counsel?
No, that.
Then please tell us.
Certainly, certainly there is no obstacle for that.
Can we thrust a particular advocate or counsel upon a client that no, you must engage in? It can't be.
The
These
veracity
are
of the thing is,
professional servicing,
in wider perspective, it is to
professional
be seen.
servicing hired on contractual basis.
What I understood, not so far clad 1 and clad 2 is concerned, that is for
We will
reference
examine.
purposes.
We will examine it. We will examine.
As you lordship, please.
Obliged.
Next.
Wait, please. Lords, the only dispute which we have is that the lease agreement says that.
First you don't appear there, then.
No, so therefore, Lords, I am not taking anything in my favor by saying that I was not there. I am only saying, had I also been there, Lords, clause 12 of the lease deed should have been followed. Please have clause 12, Lords, at page 40 of volume 1. There ought to have been 3 arbitrators, and in fact,
You have done your best to avoid everything, to delay everything, and
2-3 things, Lordship, may allow me to show, Lords.
raise all the contention before the arbitrator. Already High Court has, what else the High Court could do for?
Lords, 2-3 things only. Page 40, clause 12, Lordship sees of the lease deed. It envisages, Lord, 3 arbitrators in case we do not agree on a sole arbitrator. Now, your Lordships kindly see the impugned order itself, Lord.
The order passed by the High Court in the review IA number 2 of 2025, we see no ground to interfere with the impugned judgments, impugned orders, dismissed.
We were only wanting to show one thing, Lords, that, just allow me one more second. I know your Lordships have dictated, Lords. The respondent himself said appoint 3rd arbitrator. Still, the Honorable High Court says I'll appoint only 1.
So after having derailed the arbitration mechanism, when section 11 triggers in, you have no right to retrace.
But the respondent before your Lordships also prayed to the Honorable High Court. Lords, 4 weeks for my statement of claim, Lords.
After the arbitrator, let him file.
Madam.
Where is Mr. Mehta? What happened yesterday matter they were to inform us?
1 minute. Lords, the Honorable High Court gave us some time for filing statement of claim. Lordship may extend it. No? They were in the process of challenging the order here.
You already successfully delayed it. How long you want?
Lords, I just reply to their statement of claim, then file my counter claim. Now, only for pleadings, please grant me 4 weeks from today.
However, in the interest of justice, 1 week more time is granted to the petitioner to file the claim statement or reply thereto.
Lordship, the Chief Justice may say 2 weeks, Lord. 1 week.
No, nothing. It's all delaying that.
Lord, delay may be condoned. It is against the first impugned order. We had filed a review, Lords. Grateful.
Isn't this? That's the respondent petitioner here, my lords, have been left remediless, my lords. The document placed are, my lords may have the practice direction was.
Arbitrator to decide, then you keep on.
There are still, when we filed this application, 9 months were still there, my lords, for the arbitrator. Para 13, my lords, may kindly have of the Honorable High Court order. We have no other remedy, my lords.
We see no ground to interfere with the.
My lords, may kindly see the
order passed by the High Court. How taking a lenient view, the para 14 of the impugned order to the extent of imposing of cost of rupees 25,000 is satisfied.
obliged with the, my lords, obligation, but only one, my lords, if I may allow, my lords.
Nothing.
My lords, these documents, otherwise our case will be prejudiced. We don't have any,
Next.
and it was allowed by the arbitrator itself. Obliged.
25. It's appearing item 25. Item 25, my lords. 25, yes. I'm seeing transfer of FIRs. The law is clear now. I'm not seeing transfer of FIR in Calcutta to Bombay. There are multiple FIRs lodged in Bombay. A lordship
So?
done that in the past.
So,
Seeing consolidation of FIRs in that particular
Why?
state.
Why, sir? You go on cheating people across the country and they have to prosecute you at a place that you choose.
My lords, I'm not choosing a place at
No, we are saying you have the audacity to come to us to get an order.
My lords, I'm not seeking a
Hundreds
custody.
of
You are
crores of-
seeking an order.
I'm not seeking a particular security. Lordship,
You are seeking an order by saying as someone who is cheated in Siliguri has to prosecute in Mumbai.
No, I'm not-
Someone who is cheated in
No, I'm just
Bangalore has to
clarifying that.
prosecute you.
I'm just clarifying that I'm not seeking Siliguri to Bombay at all. I'm seeking Siliguri in Siliguri, but then multiple in Bombay.
Like a load there, and the victims will come, poor fellows, and they will, with folded hands, come to
The
you.
lordships have done that in the past. Let's you can see that.
Let's keep it, the judgment with you.
No, I'm not seeking a transfer from Siliguri to Bombay. I'm seeking Bombay. In Bombay, there are
In
multiple
Bombay to
FIRs.
Bombay, you have got the High Court.
High
Go
Court.
to the High Court and
Go to
seek
High
a
Court.
transfer.
That's the lordships have
Or
done
do
that.
one thing, you deposit 200 crore rupees with our registry.
Yes.
Show your bona fide, then we will definitely like to examine.
Use, deposit the entire days.
I'll withdraw it, my lords.
Entire
I'll withdraw it.
country, you have taken gold ornaments from people and not paying them.
I'll withdraw it.
Commies.
Go to High Court.
I'll withdraw it.
Let concept of the petition seeks and permitted to withdraw this petition. We will be able to approve the report.
The main accused, Lord Shankar Lal, who was assigned them an injury mill on the fatal injury, he was granted bail by your lordship. Now I have also undergone about 7 years, Lord.
Mr. Jaina,
You know, I have also undergone about 7 years, Lord.
6 years.
6 years only.
And the
6
person
years,
who
9
got
months, Lord.
The person to whom we granted suspension of sentence and bail, he had completed 9 years.
8 years or something, Lord.
9 years.
9 years, 9 months.
9 years, 9 months.
Yes, ma'am.
General principle is on, sometimes on merits we can grant even after a month. That's a different issue.
Even merits, my Lord.
But general principle is 10 years. In 302 matter, the guidelines laid down by this court is that once you complete 10 years, we grant suspension of sentence if we are not able to decide the appeal. 10 years, sometimes we stress to 9 years, some months, like in your case,
He is the
But
main
if
accused, Lord.
9 years are stressed to 6 years, then there is no limit.
He is the main accused. My role is equivalent to the.
Both are main
I've been
accused.
acquitted, my Lord.
Both are
My,
main accused.
my role has been just equal to the.
Wait for some time. Wait for some time.
About 6 years, 9 months, my Lord.
Otherwise, see, once we relax on this, sometimes misplaced sympathy creates problem. If we relax this guideline,
He's not
then we will be
main
relaxing for other cases also.
He is not the main accused. Main accused is a fatal
All are
injury,
main.
Lord.
My lord, I appear for the complainant impleadment. I have moved an application for impleadment.
Have you
My lord,
asked
my
for-
impleadment application may be allowed.
Wait for.
Your Lordship,
We have heard. and
I may move after 6 months or something. Lord.
Applicant, 3 years. Applicant,
No, my Lord.
it means that
He is not the main accused, my Lord.
we are not inclined
It is
to-
equivalent to main accused.
trying to suspend the sentence of the applicant. Number 2, applicant of land number 2 at this stage. He shall however be at liberty. Is this lady or male? He shall however be at liberty to apply at an appropriate stage. With liberty of aforementioned, the IE is dismissed. There is another IE by the complainant for impleadment. The complainant is allowed to assist this court at the time of final hearing.
I'm grateful, my lord.
Oblen.
What is he doing?
May I please, Your Lordship,
In item 5, my lord, on behalf of petitioner,
accused has joined, Your Lordship. As
I
per
am
my
joining-
instruction, he has joined, Your Lordship.
in terms of the last order, my lord.
He has joined.
Yes, please.
My lord, I am the petitioner in this matter. In terms of the last order, I have joined the investigation. My lord, I got the receipt as well, and same has been acknowledged by the state government also, my lord.
He has joined, Your Lordship. As per my instruction, pursuant to the order of 26/11, Your Lordship, he has joined on 28th.
This is the anticipatory bail application, my lord.
Now you have joined the
Yes,
investigation.
my lord.
Yes, Your Lordship, he has joined.
And we record his undertaking that in future also, when required, he will appear.
Yes, Your Lordship.
Yes, my lord.
And state council on instructions with reference to order dated 26 November 2025 and State Council on instructions very clearly states that the petitioner has joined the investigation. In this view of the matter, will dispose of this matter that the interim order dated 8th October 2025 shall continue to operate. Subject to the condition that the petitioner shall appear before the investigating officer as and when required till the investigation is completed.
Much obliged.
My lords, no counter has yet been filed.
My lords, I had short, your lordship, 1 week's time, your lordships. The counter is ready because, your lordships, there were various FIRs across. However, your lordships, I leave it. Your lordships, I will not. I will leave it to my lords.
Trying to persuade your lordship that your lordship has already granted bail to the shooter. My role is much less. Anyway, my lords, entirely.
After 1 week, no further opportunity shall be granted. Post the matter, exact after 1 week. Today is what? The next Thursday or Friday.
Highly oblige, your lordships.
I may need to respond to the so
Your advance.
Yes, your lordships, will give.
This only probably State Council do their formality. Otherwise, who reads counter evidence in bail matters? And what if?
Having been a state council myself, my lords, I will. Having been a state council myself, my lords.
Yeah, that's right. You must have seen it.
Oblige me.
Highly oblige, your lordships.
Yes, Mr. Dutt, have you helped us?
My learned friend, my learned friends on the other side in the evening have sent, my lord, seeking to 8 or 9 hotels. They are seeking whether those are available and what are the rates. In the evening they have sent. No response from any of the hotels as yet. 3 hotels in Delhi, 3 in Gurgaon, 1 in Faridabad and 2 in Hyderabad. Lord, my only submission is that if you look at it,
you tell us where do you want? We will tell them to make.
According to us, Lord, we have booked London IDRC, payment has been made, all arrangements.
One more fact I must inform
And one
you.
of the, yes.
Only, that's up. I had a word with Mr. Diwan. He had sent me the mails received by the clients. The president is ready to come here, Madam. In Williams.
Please convey you see, we don't want to disturb this.
One more, there is a problem.
India is responding very well, and it can only happen when the bar will be very encouraging.
We have, as I said, we personally have no difficulty at all. The only issue
is legal issues we have heard. We appreciate, but your subsequent cooperation also we really acknowledge. We want to acknowledge that. If you, to that extent, you should.
No, the only difficulty is one of the members of the tribunal has written that he will not be able to come to Delhi during this period.
He can join all.
Yes, Justice Joseph is here.
My submission is this.
But which place are you offering them?
Their choice, my lord. I have given them options.
Today they have just written asking for quotes and, my lord, whether availability. Lordship knows in Delhi, my lord, marriage season, I don't think whether anything will be available. And in this last minute, my lord, whether we will...
yes. Delhi's weather has not been very encouraging. Don't worry, you will get this space. Delhi's weather has not been very encouraging for that. Mr.
May I suggest something?
Mr. You tell your officers, they must immediately find out and inform them that this is the accommodation readily available.
I have already done that.
Lord, may I
have informed them, I'll just name
let hybrid be done.
Resonate
Let
House,
hybrid be
Taj
done.
Palace.
But, from our side also, we'll have a limited team. Let hybrid be done. But that will serve the purpose for everyone. If there are 2 or 3, 4 main council and main persons can come to London, our 3, 4 people will come. Rest will all do hybrid, my lord. Today,
only
Lord,
one
the position
person.
is practically, my lord, it is very difficult. Now 10th is the hearing, will just 4 days, 5 days.
One thing, the president of the tribunal and the other member, in any case, one member is local former judge. They will be here. The third member can join online. There should not be any difference.
Yes, I have no problem.
He can join online. All of you are also here. They are also here. Please have, you see, arguing in person is that charm, Mr. Dutt, who knows better than you people. Of course, we have forgotten that art, but you can't.
No, my only difficulty is it will not be possible, my lord, in these 4 days to fix a venue which will have all the facilities required.
That's why
That's the only difficulty.
we will keep
And
tomorrow.
then, my lord, it really would tantamount to changing the dates, which means that it goes, my lord, 3 or 4 months ahead.
No,
And that's exactly what
which
we
hotel,
want, my lord. That's
which hotel is available?
You choose the hotel, we will pay for
my
it.
lord, I
You choose the hotel of
they have
your
written
choice.
9 hotels.
We have
my lord.
given ITC Maurya, Taj
No,
Chanakyapuri. Lord, we have given 9 hotels, my lord.
Mehta, why don't you put your some senior officer immediately contact these hotels and have a tentative booking only for
Certainly, my lord, if they are
Why
available, we
can't,
can
my
do
lord,
that.
my learned friends on the other side do hybrid? We have no difficulty. We'll also, my lord, some of us will do hybrid. The main councils will go, because, my lord, today the position is payment has been made to, my lord,
Payment
IDRC.
will pay you, will compensate you for that.
Payments have been made, all flight bookings done, hotel bookings done, everything has been done.
Flight bookings
We are
can be
standing
cancelled,
right
my
at
lord.
the
We do
threshold
that.
of the hearing. That's the only difficulty. If we had, my lord, time, 1 month's time of, or something like that, then
We
possibly.
will request you, please, both sides should not invite any order from the court.
My lord, I am only saying, my lord, this.
Because I will not be able to hear, my brothers are not with me right now, and I can't do anything. We have heard the arguments, but we still hopeful that you will please avoid the order. And reasons we have said in open court, it's not encouraging for both sides.
My lord, my learned friends, what is your objection with hybrid, my lord? We will also, most of us will do hybrid.
No, you do it.
Two members are ready to
President is
come.
ready to come.
Exist for that.
President is willing to come.
Yes.
One member is of Indian origin. He is already in India.
Yes.
2 of them are here. The third member can join online. Your other council can also join online from there. No difficulty. We'll make that arrangement.
No, that is not a problem, my lord. The only problem is logistics. Now, within next 5 days, my lord, it will be absolutely, my lord,
Lawyers are ready. You see, whether you argue in this courtroom number or court number 4, how does it
Here,
matter for
here,
you?
my lord, the issue is slightly different. My lord, there are 75,000 documents, all, and there is live transcripting.
soft
Everything is done by a agency which has been hired, my lord, in that agency is based in London. It's a company called Epic. So, my lord, entire live transcripts and also showing online all the documents, etc. And there is a huge, my lord, they have their equipments. All that arrangement has to be done, and Wi-Fi, which is really effective. My lord, all that within 4 days. How do we do it? That we were not able to, my lord, agree on these 3-4 hotels. In fact, their secretary came in September, and my lord, he looked at, and both sides said only these 4 hotels we look at.
Mr.
And
Dutt,
the secretary
Mr. Dutt,
that was inadequate.
Then the only way out is that we stay the proceedings and we pass in judgment. Then whatever we will take, we'll take.
That I, my lord,
Because passing stay means that everything goes west. Today, if we can't deliver judgment in a day. It will take some time.
Yes.
And if we stay everything,
we are confident we can, my lord, persuade my lords, my lord, to take a different view. Just 3 judgments I will show. My lord, I will not take more than 5 minutes.
frankly speaking, it's possible. We are not saying that we will not take a different view, but we can't take that view today. It will take 10 days, 15 days, 1 month, whatever time it takes. I can't promise that I will deliver the judgment in a day or so. I will have to spend some time on it. But till then, this entire this schedule will be frustrated.
My lord, that I see, if your lordship is prima facie of that view, that schedule will in any case go, because I don't think, my lord, in the next 4 days, he's written, my lord, only in the evening yesterday to 9 hotels. None of them have even, my lord, responded. And that is only as regards rates.
No, I have written to you that you choose the hotel.
No, how? Sir, we had this discussion. The secretary of the tribunal, my lord, from Singapore came. He's also an eminent lawyer, my lord. He's the secretary of the tribunal. He came.
All are eminent lawyers involved. There is no doubt about it. All eminent lawyers, eminent jurists are there. In this kind of international dispute, they are bound to be there. There's nothing. I mean, that is what we expect.
So he came here to see whether hotels are suitable.
No, at that time, my lord,
So therefore,
four
we
hotels were
give
under
them
consideration.
options of hotels.
And they didn't, at that point of time, they didn't suggest anything else.
That you started with the problem of hotels not being available. we will make sure that they will arrange for you. One, two, they will arrange within the budgetary limits which you had suggested. Rest of the cost we will impose on them. That also we will pass an order today. And you make your arrangement. 4 days is more than sufficient time even to come and make everything. Or the third person, yes, understandable. One of your member is unable to visit. He can join hybrid. All of you are here. Instead of you people going there, you are here. Let only 1 or 2% is required to travel there. Let them come here. Those who can't come, they can join hybrid. There is absolutely no difficulty.
Lord, I leave it to my lords. My lord, my instructions are that, my lord, it is now virtually impossible, well nigh impossible to have, my lord, a hotel, a place fixed with all the facilities in place, my lord. And all payments for IDRC, etc. have been made. All, my lord, hotel bookings there in London have been made. Today, my lord, all that is non-refundable.
These are all cost factor in the award. These
Lord, their only main grounds is that cost.
In the final award, in the final award, these are very minor amounts. These can be taken care. These are very small expenses.
Exactly, my lord. That's why I said, my lord, ultimately, my lord, they also agreed when in the first instance when hearings took place in London, my lord, that time the tribunal had made it clear that the seat is Hyderabad.
That, as pointed out yesterday, there is a grey area, there is some vacuum. Then we would like to deliver a judgment on it.
I am also supported by judgments, my lord, but I didn't want, my lord, that. Therefore, I immediately gave them 9 options of the best hotels. They can choose the venue also. Venue in the sense, Goa, city, I mean, Hyderabad,
said then done.
Bombay.
Today is wedding season in Delhi. And, my lord, in all over India, in fact.
Why you insist even for Delhi? Why don't you go for a nice place?
Anywhere, Lord, but everywhere, Lord, there is
Hyderabad.
Availability.
Why are you bothered about it? We are telling them that they will arrange for you. You please name the hotel in Goa, they will arrange. You name any hotel in...
Personally, we can find out, but the point is this, my lord, whether in the next 4 days, because arbitral tribunal also has to, my lord, the 2 members who are to...
Mr. Dutt, it is only because of the uniqueness that we don't want to be an impediment in the development or promotion of international arbitration within our jurisdiction.
Yes.
That we are seeking your indulgence instead of doing indulging from our side. When therefore we seek that much cooperation from you. Please do that. You go in 10 minutes, you can find out online. You go have a cup of coffee with Mr. Mehta in his office and you will find out the hotel. Best of the hotels are there. And logistic issues, you tell us, we will issue directions. After all, they are, if they want to be the willing host, they will have to bear something.
Lord, that is a separate matter, totally, my lord. All I am saying is, what is their, my lord, objection to hybrid? If one of the parties can, in fact, one of the president is in US, I am told right now, my lord. She said, I am unable to come to India or London, whatever is.
So, very kind of him that he is willing to come to India. I mean, that shows he is absolutely with open mind. There is no. So he should be well.
Therefore, my lord.
So out of 3, please see the balance of convenience also. One is willing to come to India. He is not in UK also. He is not in India. He is willing to come to India. One is already in India. The third is not in India. He might be in Europe. Let him join from there only. We don't want to cause any inconvenience to him. Let him join from there. You are already here. Your top brass lawyers are here. They are to argue. They are also here. Their officers are also here. Your team is also here. What is the problem?
The clients, some of them are abroad. It's a foreign company.
They can come, they are not very small.
I'm not on that. If, Lord, we had time, yes, certainly we could have, Lord.
Therefore, yes, time is running fast.
Lord, we have intimated them on 25th of 11/25 that please don't make any arrangements. We are moving the Supreme Court. There is a letter written to you. Anyway, I don't wish to go into that technically.
This, Lord,
that issue
if your lordship feels that there is a grey area, my lord.
We are only trying to resolve it amicably so that maybe I need not to repeat what I said.
Lordship has made it very clear, my lord. We know what is going through your lordship's mind.
Both sides. And we told you that how it is going to impact both sides. Therefore, we just thought that you come out with some good solution. And with person like you, sitting there, and both of you should. I expect.
Personally, as I said,
we have choose the hotel. You make the arrangements yourself. We'll pay for it. But what more can I say? The best hotels we have suggested, ITC,
If there
Maurya,
had been time,
Taj,
15
Hyatt,
days, 3 weeks, within 4 days, Lord, how everything can be done?
But whatever we have been hearing, ITC Moria, I have never seen from inside, except might be attending some weddings.
Yeah, yes, Lord.
But this is one of the best hotels in Delhi. Have please enjoy their hospitality. And if we are also sitting here, if you find any difficulty, we will solve it. Now don't give second thought to it, please.
Lord, may I
Sometimes court's advice.
my Lord, may I request a password? Let me confirm.
Yes, yes.
And,
No difficulty. But think of it, ITC Moria, they will make their alternate
don't know whether
anywhere
it's
else.
available. They've written, in fact,
Subject to
ITC
availability. Obviously, my lord, we can't commit subject to availability. These
That's
are
the
the nine
problem.
options.
You immediately find out, Mr. Mehta. You tell your officers to find out. Right? They should also not create uncertainty.
No.
Whatever.
The moment they say yes, my lord, we'll immediately find out and we'll book it also. My lord. There is no.
Whatever is available, the best. You inform them that this is available right now, and then immediately they can book or you can book for them. Cost part factor can always be adjusted.
That is ultimately tribunal will take, my lord,
Yes.
decision on the cost.
So we expect a lot of cooperation from both. We'll take up at 5 minutes before 1 o'clock.
5.
Please, my lord. Oblige.
Item one is an early hearing application at 2011.
Yes, item 1.
Item one is an early hearing application.
Please, service matter, wait for your turn. 2011 matter, it will be taken up.
11 will appeal.
Just put you on the call list. We'll try to get it listed.
Oblige.
Yes, I was suggesting pursuant to the last order, this can be referred to mediation, my lords. Lordships have recorded my statement on the last order.
We will be glad to pass an order of early hearing in all the pending cases.
No, my lords, I was referring it to mediation. Just have the last order.
We are objecting, my lord, we don't want to go to mediation.
Oh, you don't want to go to mediation? Oh, I thought because
Why don't you want to go to?
My grandfather, he sold the property during the minority of my lord.
So what? It can always be dispute is there, dispute can be solved.
Yes.
What is this mindset that you don't want to go to mediation? Whole country is going for mediation. Why you should?
last order, Lordship may see, my lords. My
Pandey, we don't expect from the senior counsel like you to say.
The children who were deprived from the property in their minority,
You should be
despite the
part of the.
election, there was an order by my lord.
Petition.
And the first document was prepared.
On the suggestion and request of learned senior counsel for the party, the matter is referred to the Supreme Court Mediation
Lords,
Center.
can I request? Can I make a request?
Yes,
You are also there.
Yes, please.
From party.
Yes, I am for the minor, whose parents have been.
Then you have one of the mediators already representing the party. Even he will be able to do it. Try to resolve it. Some give and take can always be there.
Yes, ma'am. Can some learned senior counsel or retired honorable High Court judge can be appointed? It's a little complicated dispute. If he can give some time, I have no.
If you agree with us,
Yes,
we will request Mr. Saxena to be the mediator.
I have no difficulty. Mediator is anyway, but if he appears for a party, it becomes a problem. That's a difficulty. I have absolutely no difficulty, but if we make a proposal and say things, then he can't represent a party, then he will lose out. That's the only difficulty. I have been a mediator all number of matters, but I feel that, as a mediator, a lot of times I am privy to information which I shouldn't share with anybody.
Who else can be?
It's a fight between David and Goliath. That's all I can say.
I am prepared to come down and become mini David.
Came from Punjab and purchased huge property in the backward area of Bundelkhand. And this minor's parents were murdered.
Anyway,
That's my mother. And that's why in injunction, specific order of court, they sold the property without seeking permission of the court. 3 courts have held against him. Your Lordship is guardian of the minor.
There is no chance but
no difficulty. Lordship may put it for hearing because it was heard, by Justice Bikram Nath last year. I made a suggestion.
let's give some date in March.
Grateful, dear Lordship. Very obliged, dear Lordship. Grateful, dear Lordship.
Lordship.
Please, Lordship.
Your Lordship, I'm seeking a short passover in this matter. I'm seeking a short passover in item number 3.
Non appointment.
Yes, ma'am.
क्या सर्विस मैटर एक्विटल हुआ है उसको रिटायर
2013 advertisement, my lord.
acquittal we want it again reinstatement we said
Your Lordship, leave was granted in this matter on 21/11/2024, and it was directed the matter to be listed in March 2025. However, it has not been listed up to this application, Your Lordship.
What is your stand otherwise?
My lord, there are concurrent orders, my lord. He was prosecuted under 376, my lord. Therefore, appointment order.
Your Lordship, he was honorably acquitted in that matter. He was honorably acquitted in the matter that my friend is
The
mentioning.
finding seems to be that it was a consensual relationship.
Yes, Your Lordship.
Yes.
And she was a married woman.
Yes, Your
So
Lordship.
therefore, on moral grounds, the appointment order was not issued against him.
Moral ground
क्या है
But
ये कितने morality कहाँ पढ़ाओगे आप?
lordship will list it on any date.
After appointment, if there is something happens, he does something wrong, then understandably. What did he post?
Assistant engineer, my lord.
Assistant
Water Resources
the Water
Department.
Department, Your Lordship.
This is the main case in March.
Great.
Much obliged, Your Lordship.
May I please, your lordship?
May I please?
That is 3 lakhs was been deposited in the registry of this court, my lord, to show the bona fide, my lord, seeking transfer of the 3 lakhs amount was been deposited in the registry of this honorable court, my lord, to show the bona fide, seeking transfer from Nanded, Maharashtra to Andhra Pradesh, my lordship. 138 matter, my lordship.
Your Lordship, the total loan amount was 2 lakh. Now the outstanding is almost 6 lakh, Your Lordship, in the
Yes,
account. He has not
So,
even,
what happened to the order of 31st January?
he has,
2 lakhs?
he has deposited.
That was been deposited, 3 lakhs was been
That was
deposited.
deposited.
That is 3 lakh 18,000 is now lying for the registry, Your Lordship.
Now, how much left?
That is almost 6 lakh, Your Lordship.
My lordship, may I submit to this, my lordship?
Lordship, if you can pay 50,000, we can close the entire loan.
May I submit to this? Check amount was only 2,64,000, my lordship. As per check amount was 2,64,000, my lordship. As per your lordship direction, my lordship, we deposit 3 lakhs, my lord, to show the bona fide. Not 6 lakhs, my lord, as shared by the friend.
So that is the loan amount. Loan amount now outstanding is 6 lakh.
But what about the interest component?
My lordship, interest was 18%, my lord. Loan amount was 2 lakhs, my lordship.
Lordship, we are ready to close the entire loan account if we can, an additional 50,000 if we can pay.
Asking only for 50,000 now.
The 3 lakh which is lying it along with the 50,000.
350. 350 more. You are asking total 650.
No.
no he is asking for
Total 3,000 and get rid of this
My
process.
lord, may I say this, my lordship? Check amount was only 2,64,000, my lordship.
Please don't argue these matters now. For
As per
50,000.
lordship direction, we deposit 3 lakhs, my lordship, taking a transfer.
Don't forget about, earlier we had dismissed your case.
Yes, that is there, my lord.
Now we revived it only because you showed your willingness. Yeah? Write down. The petitioner was held guilty in the proceedings under section 138 of the Negotiable Instruments Act 1881 in a complaint filed by the respondent cooperative bank. The loan was taken in January and June 2019, but having defaulted in payment of installments, the petitioner's account was classified as NPA from 1/1/2022.
These are not found.
Was a complaint given. I complained on 138 was filed against the petitioner also. He challenged the
Piece of transfer.
he saw transfer of the aforesaid complaint
From Maharashtra to Andhra Pradesh.
from Maharashtra to Andhra Pradesh. On 1st March 2024, this court directed him to deposit the principal amount of this 2,64,643 to show his bona fide. He, having failed to do so, the transfer petition was dismissed on March 21, 2024. Thereafter, the petitioner moved an application seeking revival of the transfer proceedings. The prayer was considered sympathetically and while ordered dated 27th September 2024, they are directed to deposit a sum of 3 lakh with the registry of this court. Next paragraph. It is not in dispute that the petitioner has complied with that order direction and a sum of 3 lakh stands deposited. Next paragraph. The counsel for the respondent cooperative bank on instructions fairly states that the entire matter can be resolved if the petitioner agrees to pay a total sum of 3,50,000.
And an extra 50,000, 3 lakh, which is already deposited 50,000 more, your lordship. 50,000 more, 3 lakh.
Total amount of 3,50,000, for which a sum of the sum of 3,50,000. That means the amount of rupees 3 lakh which is lying deposited with the registry, along with the interest accrued thereupon, can be released in favor of the bank. And in addition, the petitioner shall be required to pay a sum of rupees 50,000.
50,000, 50.
50,000. Next paragraph. We find the proposal given by the respondent bank fair, just, and equitable. So consequently, the registry directed to release the payment of rupees 3 lakh along with interest accrued thereupon in favor of the respondent bank within 1 week. Transfer the amounts on. Next, in addition, the petitioner shall deposit a sum of which 50,000 with the respondent bank within a period of 2 months. Within a period of 2 months. So no additional interest shall be charged on that amount of rupees 50,000. On deposit thereof, the claim of the bank shall be deemed to have been fully satisfied, and in that case, the complaint filed against the petitioner under section 138 of so and so shall stand dismissed, being infructuous. Next paragraph. However, if the petitioner fails to do so, comma, the complaint proceeding will continue and the law will take its own course.
Deeply obliged, Your Lordship.
My lords, just before the SIR matter which your lordships are just taking up, your lordship would be pleased to take item 26. This is that Tamil Nadu SIR matter, which we had come on Monday. Your lordship said you'd take it. I have a only small prayer. On the BLOs, my lords, I mentioned that Anganwadi workers and teachers, they are the ones who are recruited for this massive exercise. Now, we have filed an application in this. We're just seeking a small indulgence from your lordship, which is this. At the moment, we have details, and this is from the press, we have details of almost 35 to 40 BLOs who have died either through suicide or otherwise, citing the work pressures. We see that across the states, Section 32 notices are being sent to them, saying that, look, you have targets to meet. If you're not meeting that target, then you're going to be imprisoned from 3 months to 2 years. That's what Section 32 of the RP Act provides, saying that you have been negligent in whatever duties you are discharging, etc. The work stress and pressure is a constant statement that is coming throughout. My limited plea, I have larger pleas regarding ex gratia payment, etc. My limited plea right now is please request the Election Commission not to implement this kind of a harsh provision of Section 32 of the Act. That's all I'm saying. Because when you say there's punishment and criminal offenses, 50 FIRs have been registered as BLOs in one single swipe in Uttar Pradesh, for example. That's based on record. And with great pride, they say that if they are not meeting it, they will go to jail. This is not the way we should behave with teachers and Anganwadi.
You are representing the state or?
No, it's a party from Tamil Nadu.
The Election Commission who has served this application yesterday, we need time to respond to this. Yeah, we served this application yesterday. We need time to respond to this.
I'm only in the Section 32 being invoked. That's all.
We are telling something else. If the state government or the state election commission.
Multiple states, that's the electoral officers in all these states are giving the direction.
No, you are talking about Tamil Nadu or all these states?
No, in all the states this is happening. We have placed records for Gujarat, Madhya Pradesh, Rajasthan.
Kerala, your lordship had seen yesterday, the election commission was having no problem.
It's all right.
Therefore, your lordship are the states who
includes Tamil Nadu as well.
We are only suggesting that we can then call upon the state governments or the state election commission.
Yes.
To substitute these employees. Those who don't want, they can provide other employees, set of employees. But the work can't be hampered on the ground.
Yes.
Suppose if it is a lawful exercise.
Yes.
Somebody will have to perform.
I agree.
Some Anganwadis or some employees can have genuine difficulty.
Yes.
They don't want.
Yes.
But the state can substitute them.
That the state can do. I mean, at no state, but they're not being allowed to withdraw. They're not allowed to withdraw, my lords. What? Yes. Under Section 32, the complaint has to be by the election.
So that the working hours can be or the work burden can be reduced.
No, I have two suggestions. Exactly what your lordships are saying. Because right now it's not a voluntary exercise. The minute you are recruited for this, you can't say no, you can't resign, you can't withdraw. That's not permitted. Now, the Section 32 subclause 3 makes it clear that the complaint has to be by the Election Commission, not anybody else. So, Election Commission is the complainant there. Now, either they don't initiate this kind of harsh criminal action, or you give them the avenue saying substitute. Either is fine, Malad.
No, but they will, the substitutes or the list, the employees are provided by the state government.
Yes, they are. Yeah.
So they will have to talk to the state government.
They will have to. That's what they're doing at the moment. They are dealing with the state governments. My only issue, because we have issues from Tamil Nadu as well. I've placed this. First election is Tamil Nadu. I'm just saying the Election Commission is the one who's handling this and running this exercise. The states are supposed to cooperate with them.
The job in Tamil Nadu is over to the extent of 91%. And, my lord, this is not, my lord, as your lordships are appreciating, it's not my lord, splinter kind of a submission, because these are larger ramifications of the, my lord, conduct of the election. So, my lord, if your lordships are considering this, let us respond to the application.
In the meanwhile, I'm concerned about the pressures on these people.
We'll grant you time to file the reply. We also call upon the state
and the State Election Commission to be in, they are already in touch. They can come formally through the state.
Rather than being bureaucratic about this, my suggestion, I've placed on record here, a boy who had to go for his wedding on Wednesday was not given leave. He said, please, it's my wedding. They suspended him, he committed suicide. This is just one example. We have full tables and charts showing the number of people this has happened to. It's a human question. I can't understand why there should be resistance on this.
Respectful submission is let the state and the commission coordinate with
No,
the
just
election commission.
don't.
With their otherwise.
You are the
associated. Not
complainant.
that they are not in
I'm
touch
saying
with
don't
each
be a
other.
complainant. Surely you can conduct this exercise. We are challenging the validity. But I'm saying even while you're conducting the exercise, at least show human side.
Mr. Gopal, the problem is that there has been always a statutory mandate for the employees in all these states
Yes.
that they will perform their duty.
Yes.
People have been going, they are luckily working there within state. There are set of course they are higher level.
They work in the mornings, they finish their teaching job, then they're supposed to go and meet these targets. They work till 3 a.m. Uploading it without network, without data.
So therefore, let us call upon the state. Why can't they provide more employees depute on there so that their work?
That's definitely welcome, Malod. Let them do that. But I'm saying this criminal action, that surely they should not initiate. I don't think it's such a harsh thing to ask for, Malod. Don't initiate criminal action against these people.
Application?
It's IA number 313077 in item 26. It's listed today.
But then we'll have to call upon how many states are mentioned or we issue notice.
It's only election commission because the
election-
complainant is the election commission.
Mr. Gopal, election commission can't do anything unless they are provided alternate.
No, for 32, they are the complainant, section 32.
So if the employees revolt and they don't say we will not work and they can't, they don't lose the FIR.
They're not meeting targets. The notice we have annexed, I'll just show you one notice, for example. We have placed it on record. The notice is on page 84 of this application. I'll just Manoj,
See, they are state government employees.
Yes, they are.
The state government can always consider that somebody may, suppose a woman employee in family way, why she should be posted on, why she should be assigned the duty.
Yes.
Somebody can be unwell also,
Yes.
hospitalized, why he should also.
Yes.
There may be some other health reasons, though he is performing his day-to-day duty, but he cannot take any extra burden.
Yes.
So all these employees need to be exempted and the state government is obligated to provide their substitutes.
They report to election commission. They don't report to state government. They report because of this.
They are state government employees. State government only provide them.
But for the period of the SIR, when they're recruited by the election commission via the state government, they're answerable to election commission. The electoral officer is their boss. He's the one who's sending the instructions. He's WhatsApping them
election
every night.
commission on the, how can they find out from the state? State government will have to provide.
All the instructions admittedly are being sent by them. They're not denying it. They send WhatsApps every night saying this is your target, this is not what.
Obviously,
The
target.
notices are being sent by the election commission. The states are not coming into this process. The state only when the FIR has to be registered at the election.
Who has given the names of these employees?
Election commission, for recruitment.
State only provided.
For recruitment by the state, Maloj.
This is what we are.
But the
Not
problem
only
is not the
No, please not recruitment. Now for election duty also, they write to the state election commission, to the state government. State government deploy them to the.
after which they are under the control. Until then, there's no problem. I'm not saying that.
So therefore, we will ask the state government that whosoever are facing difficulty, please replace them.
Very well. Will your lordship then implement the states?
That's right.
This is what you have to do. Wherever this problem is rising, please implement the state government so that we call upon them.
We have given instances of 7 states. I'm sure it must be arising everywhere if it's in 7 states.
UTs, the 9 states, 3 UTs. Just
9
your oral request.
Yes.
9 states, 3 UTs, bullets.
If your lordship sees the IA 313077, these are human issues. In each one of these cases, there are children, there are parents, they are bereaved. What is amusing?
उत्तर प्रदेश people have
Meantime,
been lodged. CI के खिलाफ ने FIR कर दिया है.
I hope it's
अरे यार भैया ये कल कहते हैं आपको भी दिया.
Just please read page 84, Manoj, if your lordship have that. Page 84.
मैंने तेरे को भी दिया कल.
Lordship, page 84 of this. This is the notice as recently as 26 November 25. At the bottom of the page, it says, it is important to note that section 32 of the RP Act provides for a minimum of 3 months. I'm sorry, ma'am?
Who is a petitioner?
The main
Some
petition-
person or party?
In the writ petition is the political party. In main writ petition, the political party from Tamil Nadu. We have placed this application, bringing on record. I mean, they're not limited to bringing issues only from Tamil Nadu. They've brought issues from across the country to show that there's actually a much.
FIRs have been registered in Tamil Nadu.
No, in you.
Only FIRs registered in Noida.
In multiple states.
Only, the pleading is Noida.
Yes, we have placed one news report.
Pleading is Noida, 50 FIRs and 1 FIR against the ECI in West Bengal. That's what we find from your pleading.
That's correct. If you look.
Your states, paragraph 38 are the pleadings with regard to FIRs against the BLOs
Showing you
at Noida, and paragraph.
Yes. Yes, I'm showing you the actual document.
Paragraph 13, page 10, 11.
Yes.
1 FIR in West Bengal against the ECI also.
Yes.
Saying that the husband of the BLO lodged FIR that abetment to suicide.
Yes. Now, we shouldn't be getting into this.
No, we
Why
should be,
have
we
FIRs?
should be not that
Yes,
we shouldn't
because-
application.
We shouldn't have FIRs. We shouldn't have.
What is saying, blame and counter blame.
I'm saying we shouldn't have FIRs either way.
What effectively we
So
can guarantee
is
this
the
kind
best
of
way is to ensure that the
This is unfair,
election.
my lord, absolutely unfair.
Page 84. I didn't file the FIR. I don't know what it is. Page 84. Just please see page 84. What surprises me, the reluctance to even give a statement when you've recruited lakhs of people across the country.
Well,
To
I
say,
don't
no,
want
we
to
are going to
join
go
issues
ahead.
with my friend, my lord, the application
Page-
itself lacks any bona fide.
Page
There is
84.
nothing in this application, my lord, and such kind of application don't deserve to be, my
He
lord,
hasn't even
granted.
read it. Typical. Page 84. 26 November 2025. This is a notice sent by the Assistant Electoral Registration Officer. So these are the ones initiating it. At top of page 85, please see. To date, all booths in your
It is not
supervisory.
that they have appointed directly, it is the list supplied by the state government.
I
State
agree,
governments are sent.
I agree, but
kind of
just because it's supplied by the state government, can you do anything to them? They're teachers, they're Anganwadi workers. It's a human story.
Gopal,
Anything.
definitely, the state government can impose this duty on them. They are part of this obligation on the employees. They can't run away from that.
Against
responsibility.
criminal action,
There are officers who go from one state to another state for conducting elections.
no doubt. So we have never come here when a census exercise is being done or when normal general elections were held last year. Nobody came and said, look, they're doing this. SIR is time bound. They have to meet targets within 24 hours, 48
Elections are
hours.
always time bound. Elections are always time bound. So is SIR. Therefore, question is very simple. If there is a difficulty being experienced by on case to case basis.
Yes.
The state government is obligated to provide their substitutes.
Yes.
Private employee can be exempted.
Wait, on my oral plea, will your lordship simply the states then, please? I'll
That
give
is
the
state-
list.
There is somebody say right now.
Your lordship will just kindly, my lord, kindly.
General direction. This application has been moved by the petitioner in bracket dash Tamil Aga Vetri Pargam.
First you don't put my prayer, Yash, I asked you. Just put the states. Yeah, write it down.
Internally are seeking the following directions. Next paragraph. In sum and substance, the allegations are that various employees like Anganwadi workers have been deployed to perform the duties of BLOs from overlooking the extreme difficulties being experienced by them. Also, though the application gives certain illustrative instances from different states, it seems that the applicant is espousing the cause of such employees who, on account of health reasons, family circumstances, other particular individual circumstances are unable to perform the duties assigned by the Election Commission of India.
Well, I'm sorry. I just want to correct. I don't want my words to be captured differently. Clearly from this, it's the stress of the SIR. It's not individual circumstances that is leading to it. It's a stress. That's our case.
No, my lord,
That is our case. No, Mr. Singh, one minute.
No, please.
This is our case. If our case is being put across, I want clarity on what I'm saying.
It is also highlighted that where the employees are reluctant to perform the duties, the Election Commission of India is contemplating to initiate criminal prosecution against them. Next paragraph. We have heard learned senior counsel on behalf of the applicant as well as learned senior counsel for the Election Commission of India. There can indeed be no quarrel that the employees who have been deputed by the state government's State Election Commission at the disposal of the Election Commission of India for the purpose of performance of statutory duties, including under SF for SIR, are obligated to perform such duties. In case they are facing hardships, including they being overburdened with their own routine duties as well as the additional responsibilities assigned by the Election Commission of India, the state governments can obviate such hardship, for which we deem it appropriate to issue the following directions. 1I. The state governments may consider the desirability of putting additional staff at the disposal of the Election Commission of India so that the working hours can be proportionately reduced. 2I, wherever a particular any employee has any individual specific reasons for seeking exemption from duty assigned by the Election Commission of India, the competent authority in the state government may consider such request on case-to-case basis.
Well, it's a genuine or bona fide request because they can be for variety of reasons.
On case-to-case
by various factors.
A case-to-case basis, and replace such person with another employee. However, it shall not be construed or understood as if by withdrawing the employees who have been assigned duties, their substitutes shall not be provided. In other words, the state shall be obligated to deploy the requisite workforce at the disposal of the Election Commission of India, though the strength of such employees can be increased, as observed above. The application stand disposed of accordingly.
We have some other prayers. Just
96% of the forms have
1 minute.
been digitized. So
There are some other prayers in that application, so please don't dispose it of. I'm not pressing it at this moment, that's all. For ex gratia payments to the families where the BLOs have passed away, for computation of payments to them and laying down a scheme by the election. I'm not pressing it now. So don't dispose it off as all applications.
But you can file separate individual applications.
No, they said they'll file a reply. So
If the individual
let them file the reply,
application-
Malaj.
Once
Just
your
1 minute,
lordship
yeah.
have disposed of,
Hang
it
on.
deserves to be disposed of now.
Can I just-
If any genuine grievance comes later, my lord, your lordship would
For
consider it.
any other relief which has not been dealt with, the aggrieved person or the petitioner shall be at liberty to file an appropriate.
Very
Grateful. There is in fact a genuine concern, Malad, of the pressure that's on the BLO. There is a genuine concern.
So simple, the only way out is that either the state government can deploy additional manpower. Every time in the election it happens, it's not something unusual.
Malad, if in 2 months this has to be completed, Malad, it's not. But take for example Uttar Pradesh, election is in 2027. They want to complete it in 2 months. Why? Just take the case of Uttar Pradesh itself. 27 is the election. They want to complete it in 2 months. You've got a whole year. So why is this happening?
We are saying, why is the election?
Why is the election
quiet? Why
Our
is it saying that we
problem is
won't
that-
file complaint?
Our problem that how to answer this in peace will. If you are hearing the argument, let us conclude and try to.
No, but the problem is, Manoj, why is the hurry for a state which is going into election in 27? If, Manoj, you give enough time for all of us to participate and ensure that the voters list is a genuine.
No, but tell us who is telling us what is the problem, who is facing? State governments are hard.
Can I file affidavits before your lordship?
No, let the state government come and explain their difficulty.
How many will come here, Manoj? In fact, they are being threatened. We'll throw you out. We'll issue disciplinary proceedings against you not obeying our orders.
Sibyl, if the state governments are facing any difficulty, logistic difficulty, why can't they explain to us, please?
Manoj, these are teachers, Manoj. They don't have capacity to do that. Please appreciate what we are saying.
The government doesn't have capacity to explain to us.
Where, Manoj? They'll come to this court. They will engage a lawyer. Come where?
So therefore, let the state government explain to us that how many total employees they have, how many they have not been able to spare.
That's what the state is saying, Manoj. What is happening is, Manoj, these BLOs are just uploading forms, Manoj, without the information being given to the voter. They're just uploading forms, and then they are saying, we uploaded 99%, we have uploaded 90%. Manoj, who is going to test that? They say so. Whatever they say may be true, may not be true. How do we determine all this? Well, this is a very, very serious.
But all such allegations to test it.
This is the point.
When your lordship.
Everything that you say.
Your lordships that appeals be filed, they be motivated, nothing not.
Everything that you say need not be true.
No, that's.
This has to be tested.
Tamil Nadu,
How do we test
96%
it?
is over, UP 85% is over.
Manoj, we have examples,
And
such
same
a
thing happened
egregious
for the
example
entire process
of
of
what's
Bihar.
happening on the ground. But it's impossible for us to, Manoj, come here and explain all
The state of Tamil Nadu has come.
Why should the election commission register FIRs? That's our only question.
That
No.
already application is over.
If this state, it's not that first time happening. Earlier also they have been resisting it. The only way out is, Mr. Gopal, the state government should provide the other staff people. The moment.
Should have directed that perhaps is a halfway solution. But even then, there's pressure on people. Don't register FIRs. Like Mr. Sibal said, let the process go on 6-7 months. Let it go on. What's the rush?
What else the election commission can do? State police is not under their control. State government is not under their control. What else they will do?
They were
Ask for more staff.
one second.
One letter asking for more staff.
They were under
Let the
control.
election
In
commission-
Bihar, they were under control. Manoj. In Bihar, they were under their control.
Or if provided that the more staff is required. These are all assessments done at the ground level. Nobody is expert on.
How are they saying that everything is going on perfectly? They are saying that.
Bagchi was showing us 2 paragraphs where FIRs.
If the state governments have provided lakhs of employees,
No, FIRs will be registered now. That's
how many,
enough for them to
how many, let us take one example, one state, how many lakhs of employees have been put at the disposal?
About 1.3 lakhs or so, some states.
So why can't the state add 30, 40, 50,000 more?
If the pressure is on the individuals.
Today now that
Once that they've asked, Manoj.
we have now directed, let the state government take a call.
Yes.
Let us hope that they provide additional staff and
Compliance report at least, about where
So
they're
we
facing the difficulty.
you also file a compliance report and let us
Yeah,
see
we will,
that what is the,
we'll do it, Manoj, insofar as
and how
our
much
problem.
total work on average basis.
Yes.
You tell us that how much additional work, say for example, there is a school teacher or a Anganwadi worker. How many additional hours you are expecting them or they have been asked to perform?
Manoj, there is nothing, we'll place it before your lordship, Manoj.
Just
And
let
in
us
any
know.
case, Manoj, the election commission, the
Manoj,
state election commission, state, they are all, Manoj, alive to this situation.
That's everything, Manoj, that they say is the gospel.
No, whatever they say should be taken as gospel.
Because may I have a,
Whatever we say is
may I have a
doubt.
moment?
Say is the gospel.
Yes, Mr. Dwivedi, yes.
Something. Am I audible and visible, Manoj?
Yes. Yes, very much audible. Yes, very much audible.
Manoj, under the rationalization scheme, under the SIR, every polling booth is now to be only having 1,200 persons. The booth level officer and booth level agent of the political parties have simply to get signed and upload 1,200 forms in 30 days, which is now expanded to 37 days.
Only 1,000?
1,000, maximum 1,200.
1,200.
Maximum. They can
Earlier
do
it
that.
used to be 1,500. We have now reduced one polling booth 1,200 only. I don't see, my lord, how there can be a pressure, my lord, if on an average, my lord, if 50,
in 1 month, 1,000 forms. How many forms per day?
so all this is a creation of imagination and orally being made.
10 forms are in one family.
Much more than that.
If 10 forms,
And-
filling 10 form in a day is a burden.
It's not.
It's 40 a day, Malad. It's 40 a day. 40 a day. Personal
And
visits.
all the villagers are of the same one village or one and a half
I'll
village.
give you a lordship a small example, Malad. I'll give you a lordship, Malad. I mean, and that we are aware of that. I personally am aware. Malad, there's a building in which there are, say, 100 people. This has no elevator. There's no, assuming that building has no elevator, and many of them don't, Malad. You have to go to each place. How do you do that?
No.
He won't
At
be
the age of 75 years, I can walk up the stairs every day.
What purpose? What purpose your political workers are doing there?
But is this their job, Malad? Is it their job under the
They should
Your
approach the
lordships are
chief
now putting the
electoral
burden on
officer
us.
for this.
It is their job. And my political worker will not do, therefore the elector will be.
We have suicide notes, we have videos, transcripts.
Yes, now this is all politicization.
I mean, it
Lord,
can
let
be
not there
discarded
be any
if we have
politicization.
Let's hear the matter.
Anyway, also may hear them.
Let us start the hearing the matter.
Before Mr. Bhushan starts bullets, before Mr. Prashant Bhushan starts bullets, there's one thing I want to point out. Item number 17 are the Tamil Nadu matters which have gone out of the sequence now, bullets. Now, the only anxiety is this, bullets, that we also have submissions on the main legal question. Therefore, on the main legal question, after Mr. Bhushan and others from Bihar finish bullets, we also have something to supplement. So, Your Lordship, hear us.
We are pointing out, in fact, whatever be our best of ability, we have been able to study. Your case is almost same as Bihar matter which is going on. At least maybe one or two.
But there are things we have to supplement. On the we need to supplement.
That's why we want to hear in continuity. We also can't deliver judgment in piecemeal. That is our predicament.
Lordship, please.
We can't close the matter after Bihar and deliver a judgment. Because that is going to have.
In fact, in Tamil Nadu, they have said that the parliamentary law is irrelevant. We have the right to determine citizenship. It doesn't matter what parliament says, we have the
We will respond.
And then
We
it
will
says after
respond
next
to your
paragraph,
argument,
we will not determine citizenship. I don't know what's happening.
People, all these arguments will hear, but if we continue
Yes,
day-to-day basis.
Lordship, please.
We will respond to your arguments.
The moment Bihar arguments are over, we are inclined to start Tamil Nadu.
Lordship, please. Lordship.
You be ready for that.
Yes, we are ready for that.
We
When
are ready.
Bihar is over, we'll be ready for that.
My lord, only as a matter of information, my lord, as I had very respectfully submitted, 96% in Tamil Nadu and 85% in UP is over. And with regard to these 1,200 voters in each booth with so many 2.5 lakh BLAs and, my lord, more than 80,000 staff deployed. My lord, the daily status report is being put on the website every day.
And what is the authenticity of that?
So they are saying we are not aware what is happening.
What's the authenticity of that report?
Contrary to whatever is the process which is being followed, which your lordships are monitoring.
So, what is the authenticity of what they are saying? Who is going to determine
BLAs
that?
are there. Your BLAs are there.
My BLAs are there what? My BLAs
They are
means
watching
you
and
don't
supervising
visit,
and
you ask the
assisting.
political party to visit, the elector's name is taken out.
Yes,
and that's
political
fine.
parties have to set a narrative. Political parties have
The
to set a
narrative
narrative.
was that there are Guspetias in Bihar. That's why all this is being done. None was found. That was the narrative of the commission.
In fact, that is the best example to address everybody's apprehension. That ultimately it was, initially we had so much apprehension that God knows what is going to happen there in Bihar. But ultimately what happened?
No, but what happened, Malas? That was not a single person who was infiltrating. What was the reason for this? This was the reason given.
No, they have probably reduced 3 lakh or odd amount or figure.
No, Malas, in fact, there are 52 lakh people added in the Bihar. But we'll come to that later. This is not the forum to decide all that.
It's all right.
But it's a very serious issue that's going on. But anyway, we can't really say.
Grateful, my lord, deeply obliged. Grateful.
Lord, resuming I had just given a broad overview.
Yes.
Day before yesterday. Now I'll proceed one by one on that application, but I have prepared a short written note which will help your lordship.
I think written note is the best thing, Mr. Bhushan.
Yes.
With the written note, you can continue to explain what.
Yes.
Otherwise, it become difficult.
And my
to
lord, there is
reproduce
a additional compilation because most of the things that I am referring to are in this compilation, so that your lordship doesn't need to go here and there.
Your lordship will hear it for the rest of the day now.
They are all in the main compilation also,
Item 10, etc. Your lordship.
so that your lordship doesn't need to go.
But probably will argue this side.
No, I finished my argument. That's why
You have already finished now.
I finished that. But the other matters, but your lordship will not hear today. Your lordship will hear this matter.
You can again, with the, today. No other matter.
No other matter. That's all.
There is any other matter, we have date, etc. to be done.
Item 10 is there, Manoj. We are respondents, but I don't think your lordship will reach that. This is the
Item 10.
Jamshedpur Industrial Township matter. Jamshedpur Industrial Township matter.
That is about that, that will take some time. Your lordship may have it afterwards.
Comment to that, you may keep taking a date.
Any date that your lordship.
We'll give a date.
Your lordship will give.
I think I will go to January only.
I have not defected, Manoj. I am only sitting this side for that one. No problem.
Because we, before this winter break, we want to finish that.
No problem.
Army matter which we also parted and this matter. So all other matters, January.
January.
And Mr. Bhushan and all other council, this matter also we might continue only up to 3 o'clock. There is some, I might have to get up and.
Very well. So now, my lord, if your lordship takes this note.
Even 101
Today no other matter because this is good for the day.
11 also specifically posted today. This is that women reservation.
Just because SIR matter in a way will continue. These matters are on continuous basis. Like after Mr. Bhushan and the others finishing Bihar, then Tamil Nadu will start. Then West Bengal, all these matters will continue.
So, my lord, I had mostly run through one which is a kind of overview about the illegality of SIR. Thereafter, my lord, 2 is the issue of determination of citizenship. This is a very important issue. Now, my lord, first your lordship may turn to this judgment in this Lal Babu Hussain that is in this compilation.
Volume 5A, Part 1.
4A. 5A.
Part 1.
5A, Part 1 is the compilation of judgments. Lal Babu Hussain, my lord, is a very important judgment on almost the same kinds of issues which are there in this case, relating to removal of names on the ground of lack of citizenship. That is, my lord, I believe, at page.
If you can give the list of the volumes which are likely to be referred to.
We have given, this is just compilation of judgment.
Keep them ready in advance.
We have given the list to ma'am.
Now, my lord, if you
take time in finding it out, keep them advanced. Yes, please.
Turns to internal page 12 of this compilation. Para 8 of this Lal Babu Hussain. So this gives the factual context. It says 3 writ petitions were filed challenging the directive of the Election Commission empowering collectors of all districts to determine if a person was or was not a foreigner. According to the said directive, the information collected by the enumerators had to be consolidated and furnished to the collectors, who in turn were expected to get the same verified through police intelligence agencies or the like, and then decide the question whether the person concerned was citizens of India. The electoral registration officers were then expected to prepare a draft electoral roll on the basis thereof and publish it, inviting objections if any. Any person enumerated but not entered in the roll could apply for inclusion of his name in the roll. The electoral registration officer was to consider the request for inclusion of his name in the roll and decide thereon. This was followed by yet another directive dated so-and-so, by which power was vested with the ERO to identify and declare the name of foreign nationals and delete their names from the electoral roll. It was stated in the guidelines of the Election Commission that now this is important. It was stated in the guidelines of the Election Commission that the onus of proof of citizenship shall lie on the person seeking to have his name in the electoral roll. And then, my lord, your lordship must straight away come to para 10, bottom of para 10, page 15. Last few lines. On the petitioners learning that the revised electoral rolls had been published, and out of 18,000 voters registered in the previous electoral rolls in polling station so-and-so, the names of only 300 persons figured, thus leaving out 98% of the voters, thereby depriving them of their democratic right to elect their representatives. Therefore, the present petitions came to be filed. Now, Lord, next paragraph, last 4 lines. As stated earlier, they produced documentary evidence in the form of ration cards, identity cards issued by the Delhi administration, certificate of register of societies, affidavits, etc., but to no avail. Left with no alternative, they filed this writ petition. Thereafter, my lord, next page, after about 8 lines, except the documents stated in the notice and those birth certificates, Indian passports, citizenship certificates, etc. That's it. So except the documents stated in the notices, no other proof, documentary or otherwise, was entertained. In fact, the addressees were by and large uneducated and belonging to the working class, and in Jhuggi Jhopdis was overlooked. Then, my lord, after a few more lines, this notwithstanding the fact that these persons were voters in the previous election, and hence it would ordinarily appear that their cases were verified before the names were entered in the electoral rolls. This is because it may be presumed that official acts performed under the provisions of the 1950 Act or the 1960 rules were regularly done. Their names were already on the rolls, and since they were sought to be removed by undertaking a special revision, whether intensive or otherwise, the procedure for removal had to be followed. This is very important. And then your lordship may see the final directives. Next page. Having heard the guidelines suggested by either side, having taken into consideration and having heard the council, we proceed to dispose of the 3 matters by giving the following directives. 3. If any person whose citizenship is suspected is shown to have been included in the immediately preceding electoral roll, the electoral registration officer or any other officer inquiring into the matter shall bear in mind that the entire gamut for inclusion of the names in the electoral roll must have been undertaken, and hence adequate probative value to be attached to the factum before issuing the notice and in subsequent proceedings. The officer holding inquiry shall bear in mind that the inquiry being of a quasi-judicial nature, he must entertain all such evidence, documentary or otherwise, including affidavit. In fact, I told your lordship that even when you are applying for fresh inclusion of your name under Form 6, all that you have to do regarding citizenship is to give a self-declaration. Documents are only required for your residence and your age, for which, my lord, Aadhaar was said to be sufficient in the Form 6. Then, my lord, the affected person may like to tender in evidence and disclose all such material on which he proposes to place reliance, so that the person concerned has a reasonable opportunity of rebutting such evidence. The person concerned, it must be remembered, must have a reasonable opportunity of being heard. And then 6, before taking a final decision in the matter, the officer concerned will bear in mind the provision of the Constitution and the Citizenship Act extracted above, and all related provisions bearing on the question of citizenship, and pass an appropriate speaking order since an appeal is provided. And thereafter, my lord, 9, we deem it appropriate to clarify that the final electoral roll with regard to others whose names were not sought to be deleted on the suspicion that they were not citizens of India shall remain undisturbed, etc. Now, this was Lal Babu Hussain. Now, my lord, see their own directive. First, my lord, Inderjeet Barwa, just one more judgment. Same volume, my lord, page number 22. starts at page 19 and your lordship may straight away turn to page 22. Bottom, para 4, last few lines. All that the Election Commission directed the Chief Electoral Officer to do was to proceed on the basis that those whose names were already included in the previous electoral rolls, and we may point out that the electoral rolls of 1977, on the basis of which elections to the Assam Legislative Assembly were held in 1978, were not at any time challenged by any of the petitioners, should be prima facie regarded as satisfying the qualification of citizenship. And if any specific objection to the inclusion of any person on the ground of lack of qualification of citizenship was raised, it must be decided by the appropriate electoral authorities, and the burden of proving that such a person was not a citizen should be on the objector. And that is precisely what Form 7 of the representation of the registration of electoral rules also provides. And if your lordship just turns to this registration of electoral rules, that book.
So it also has volume 4, part 1, page 76. Otherwise, the book also has it. This Bear Act also has it. Bear Act, RER, registration of electoral rules.
Form 7, this is at page 174 of this book. Probably 174 of this book. Just give this. Representation of People Act 1950 की किताब है. उसमें registration of electoral rules
1860, yes.
60, उसमें Form 7.
The guidelines appended here.
ये कहाँ है?
Yes. Which form are you referring to?
Yes, my lord. This is the guideline. This is the form for voter application form for objection to the proposed inclusion/deletion of a name in the existing electoral roll. So you can file an application for deleting somebody or objecting somebody's name in the electoral roll on the ground of being non-citizen also.
Or are you referring to Form 11?
Form 7.
Page 76.
Yes, the only one thing that I wanted to show in this is that they have guidelines for the filling of application Form 7 under the same manual, under the same rules. And in the guidelines, they say very clearly,
Yes.
कहाँ लिखा है कि the onus of proof.
Para 3B.
If your lordship sees guidelines, Form 7 is for objections to somebody's name being included in the electoral roll. And guidelines number 3, it says the applicant has to tick any one option in which he intends to make the application. It can be permanently shifted, already enrolled, or not Indian citizen. He must also tick any of the reasons mentioned below the option as to why the person against whom the objection is made is not qualified for inclusion. He has to give reasons. That is due to death, underage, absent, permanently shifted, already enrolled in the electoral roll, on the etc., or not being an Indian citizen. The onus of proof to substantiate the reason given for objection to removal of name lies with the applicant. So you have to give reasons as to why you believe that this person is not a citizen, and the onus of proof is also on you if you want somebody's name to be deleted.
That can't be any doubt. If there is somebody a voter in the voter list, you can't exclude without giving a reason.
Yeah, you can't, and the onus of proof is on the person who objects. This is all that I wanted to show. Now, your lordship may see their own directives of Election Commission in the case of Assam. Before that, my lord, your lordship may see the directions in the SIR guidelines of 2003. So now Election Commission refused to share the guidelines of 2003 which the Election Commission itself had issued. From a whistleblower, we have filed them. Now see the guidelines. Lord, that is in volume.
It's an additional affidavit dated 8th October. I had given it in the list. Page 47.
Starts at page 47. And your lordship may first look at para 32. It's all right, don't worry. Para 32, page 51. This is now Election Commission's own SIR guidelines of 2003.
Yes.
Para 32, page 51. It is clarified. Has your lordship got it? Para 32, page 51.
Para 32.
Yes, 32.
No, page 51 is para 6, 7 and 8.
It's 60.
60. Para 32, my lord. Maybe page 60.
Oh, para 32 is page 60 probably. It
Yes.
is clarified that it is not the job of the enumerator.
It is clarified. Now, very clear instructions in this SIR. It is clarified that it is not the job of the enumerator to determine the citizenship of an individual. However, they have the power and responsibility to exclude any person on the basis of qualification for registration regarding age or ordinary residence. Age can be verified with reference to but not restricted to the birth certificate, school certificate, passport, whatever, wherever available, baptism certificate, etc. Ordinary residence may be checked with reference to various other documents. Then your lordship may come to para 75, which would be 3 pages thereafter. Or a few, no, many pages thereafter, my lord. Para 75. Page 72. Huh? 72.
72.
75, para 75. It says, in case an objection is filed in Form 7 seeking deletion of name from the electoral roll on the ground that the person objected to is not a citizen of India, the onus of proof shall lie on the objector. It shall be ensured that such onus is discharged in accordance with law. So, my lord, in this SIR of 2003, in the Election Commission's own guidelines, it was stated firstly that it is not the job of the enumerator to determine citizenship. And secondly, that if somebody objects on the ground of citizenship, onus of proof is on that person. Now, my lord, your lordship may see their directives in the Assam revision, which Assam ka the concept page.
370 part 2, volume 4 part 2. Volume 4 part 2. Part 2. Volume
We will take up that. We'll take up that. It is not finishing today. It will, by that time, Monday, that will also come.
Volume 4A, I believe, my lord.
Volume 4A part 2.
Part 2.
451.
Page 451. नहीं 448 है हमारे में तो पैरा हमको ये देखना है वेरिफिकेशन बाय पैरा 8 कौन से पेज पर है
49.
पैरा 8
49.
448 probably अगर ये सही है पता नहीं सही है कि नहीं yes correct हाँ this one 448 Volume 4A, Part 2, page 448.
Yes.
Verification by electoral registration officers. And 2, the electoral registration officer should ensure as far as possible that only names of Indian citizens are born on the electoral rolls. But basically, it is not the electoral registration, not for the electoral registration officers to determine whether a particular person is a citizen of India or not. This determination is to be made by authorities with responsibility under the Citizenship Act, the Foreigners Act, and the Illegal Migrants Act. However, the electoral registration officer has to decide for the limited purpose of preparation revision of electoral roll whether a person is eligible for inclusion of his name in the electoral roll or not on the ground of citizenship, as citizenship of India is an essential condition for such registration. Now, Lord, what does this mean? This means that if a person has been declared to be a non-citizen by any of those competent authorities under those three acts, then yes, you remove their name. But you yourself are not to determine their citizenship. You can refer those cases to those authorities under those acts. Once those authorities determine that you are not a citizen, then you can remove the name on the ground of citizenship. That is the directive. Then, my lord, 451, para 8.8. The electoral registration officer shall, on receipt of verification reports from the local verification officers, consider the same. Where he is satisfied on such report and such other material information as may be available about the eligibility of a person, he shall allow his name to continue on the roll and include it in the final roll. Where, however, he is not so satisfied and has reasonable doubt about the citizenship of any person, he shall refer all such doubtful cases to the competent authority under the Illegal Migrants Act or Foreigners Act, or as the case may be. For the convenience of the electoral registration officer, the Commission has devised a pro forma for making such a reference, which shall be adopted by the EROs. While making such a reference, the ERO shall furnish to the competent authority all documentary information collected for this purpose, etc. Then, my lord, 8.9. Pertaining to the person concerned, and shall also inform the person concerned about the case having been referred to the competent. 8.9. After the ERO has referred the case of a person as aforesaid, he shall await the decision of the relevant tribunal in relation to that person and act accordingly to such directions. So therefore, my lord, very clear. First, my lord, from the judgment in Lal Babu Hussain, Inderjit Barua, thereafter, my lord, from their own SIR guidelines of 2003, thereafter from their own special directions given to Assam, that it is not the job of the ERO, etc., to determine citizenship. All that they can do is to refer it. If they feel that your citizenship is doubtful, then with the reasons for that, they can refer it to the competent authorities and await their decision. Whether it is the Home Ministry under the Citizenship Act, whether it is a Foreigners Tribunal, whether it is a court, these authorities alone will determine, just as, my lord, unsound mind. Unsound mind is also a ground for deleting a person's name, but that determination has to be made by a court and not by the Election Commission. Then, my lord, and they have also directed on the next page, page 452, in this, that the directions given by Lal Babu Hussain have to be followed. Para 5 on Roman 5 on page 452, they have referred to Lal Babu Hussain, quoted Lal Babu Hussain, and said that these are the directions that you have to follow. Then, my lord, coming to, they have given now what they did in Bihar. Now, we don't have the exact numbers of how many people were issued notices regarding their documents for deletion of the names who were already on the draft electoral roll. What we do know is that about 3.5 lakh people's names were deleted from the draft electoral. They first prepared a draft electoral roll. After that, finally, when the final roll was prepared, 3.5 lakh names were deleted. And even after the final publication of the electoral roll took place, final roll, after that, about 3.5 lakh names more were added before the voting, between the time of the publication of the final roll and between the time of voting. In fact, my lord, that figure, what page kahan gaya that? Just take this, this will give your lordship a bird's eye view. This is from the Election Commission's own records. There is no doubt about these figures. When SIR was announced, my lord, there were 7 crore 89 lakh people in the electoral roll which existed. Thereafter, my lord, 65 lakh deleted from the draft roll. When the draft roll was published, 65 lakhs were deleted. They said that those who didn't fill up their enumeration forms, their names have been deleted. Then, my lord, number of voters left were 7 crore 24 lakhs. Then they say that 21 lakhs plus were added through claims in Form 6 during the period of claims and objections. Now, unfortunately, my lord, they didn't allow the people whose names were deleted, 65 lakhs whose names were deleted, to come in through any other way except by filling Form 6. And Form 6, as your lordship sees, is a form for a new voter, where you have to declare that you were not in the electoral roll. Actually, they were on the electoral roll. So in order to fill Form 6, they would have to file a false declaration that they were not on the electoral roll. Whereas, in fact, they were. Just as in the Citizenship Amendment Act, they are saying that those who want to apply for citizenship under the Citizenship Amendment Act, they have to file a declaration saying that they were citizens of Bangladesh or Pakistan and they came here due to religious persecution, etc. Whereas the fact is that at least in Assam, the vast majority of the people who were excluded from the NRC, who were not in the National Register of Citizens, were not citizens of Pakistan or Bangladesh. They were in fact, Lord, Indian citizens who didn't have the documents. Today, if you say that for determining citizenship, you have to produce the following documents, any documents. Unfortunately, my lord, in a country like India, at least 20-25% people will be excluded, but because they cannot produce any documents in a poor country like India. All that they can say is that I can give an affidavit that I was born here, I have been living here since this time. And I can also give an affidavit of 2 of my neighbors attesting to this fact. They don't have any documents. So therefore, my lord, these people who were asked to fill Form 6, many of them, these 21 lakhs who were added through Form 6, many of them would have been those whose names were deleted from the draft roll, but who were forced to fill Form 6 because the Election Commission said that, look, there is no other way of getting in, you have to fulfill Form 6. If your name has been deleted. Thereafter, my lord, voters removed through objections in the same period, 3.66 lakhs. But my lord, yesterday, day before yesterday, somebody from Bihar, who's a very responsible person, came and told me something very shocking. And this is something which your lordship should ask the Election Commission to specify. They said that though only 3.66 lakh people were deleted through objections, notices were issued to 26 lakh people, 26 lakh people. A cyclo-styled notice saying that, look, your documents are not adequate or your documents are not enough, and therefore you come and prove your case. This kind of cyclo-styled notice...
Those 26, how many were dropped?
3.66 were dropped. Now, what I am told is, what I understand is that in many cases...
Is it that, Mr. Bhushan, out of those 26 lakhs to whom notices were issued, that was approximate 15%, half lakh,
14%
were accepted.
Yes, yes. 86% were accepted, 14% were dropped. But, my lord, the point is, you are issuing cyclo-style notices to these people without giving any reason as to why. These are people who were dropped from the draft electoral roll without giving any reason which the form requires, which the rules require. You give some reason as to what is the problem. What are you doubting? You are doubting my residence, you are doubting my age, you are doubting my citizenship, and for what reason? For what reason? Unfortunately, though the election manual says that all these forms of claims and objections must be put out on the website, must be given to the political parties and put out on the website, none of it has been put out on the website. Therefore, my lord, today, I as a citizen cannot verify, cannot find out how many people were issued these notices. All that I know is that some people who were issued these notices have shown me the notices, and the notices are cyclo-style notices, not giving any reasons for why what is suspected, why it is suspected, etc. So therefore, because one of the issues that we are raising is transparency. It's a very, very important issue. And the standard notices, my lord, we have annexed some of them. They were just, I can tell your lordship that they were just cyclo-style notices, not giving what is it that is being suspected about me, what is it, and on what basis they are suspecting this about me. Just cyclo-style notices. You come with your documents to my office and show. What do I show? When Lal Babu Hussain said that you have to give reasons, you have to state as to why a doubt has arisen, as to why your name should not be on the electoral roll, what are the basis for the doubt having arisen. Yet, my lord, that's not big. Now come to the issue of transparency. In this, my lord, I have, in this written note, I have mentioned what are the problems. Firstly, para 3, page 2 of this note, I said, ECI did not disclose the list of voters deleted from the 25 roll until forced to do so by this Honorable Court by order dated so and so. They first didn't even disclose that. Then, digitization of claims and objections. Although ECI's press note indicated the number of claims and objections received for certain constituencies, lists were provided. These were never made available online in the required clickable format, that is the format where the form could be accessed by clicking on the entry in the list. And this is the manual. I have quoted the manual, my lord. Para 11.3. Actually, my lord, that manual, Volume 4A, page 235. If your lordship just looks at that manual, I want to show another paragraph.
Where are you referring to this para 11?
Para 11.3.4 of the manual. If they're just handing over the manual. Volume 4A1, page 235. We have annexed the whole manual. This is in chapter 11. Chapter 11 is, my lord, dealing with this whole issue of revision of electoral rolls. Now, page 235, my lord, at the bottom, 11.3.4. Digitization of claims and objections.
Under head number 3, in your note it is reproduced.
Yes, the first part is reproduced, second part is not. I wanted to read 11.3.5 also. Digitization of claims and objections. In order to facilitate the political parties and other stakeholders and bringing more transparency in the process of electoral registration, the Election Commission has directed that all application forms should be computerized on a daily basis. and list of these applications be posted on the website of the Chief Electoral Officer of the concerned state on a day-to-day basis. The status of each application forms should be clearly visible on each row of the list. Further, the web application used for this purpose should also provide a facility that on clicking of any row on the list, the concerned application form can be printed by any citizen, Therefore, my lord, their own manual, which is their Bible, their own rules, provide that this has to be done. And see the next paragraph. List of claims and objections should be made available by the ERO to all political parties at the end of each week. From the beginning of the period of filing claims and objections, the ERO shall call a meeting of the recognized political parties and hand over to their representatives a list of claims and objections received till date and obtain acknowledgement for the same. The practice of giving claims and objections to the recognized political parties should continue until the period of claims and objections is over. It is further clarified that the names included in the list once given need not be included in the next list. In other words, the list should also be simultaneously displayed on the website of the ERO, notice board of the electoral registration officer and polling station. Therefore, my lord, the manual provides very detailed instructions about the transparency that they have to follow. And today, my lord, I am informing your lordship that in Bihar, they did not do so at all. And they are not doing so even now. Even in this exercise going on in the other states, they are not doing so. And then, my lord, on the duplication, just see, my lord, deduplication.
Yes.
On this very thing, page 205, my lord, at the bottom.
Yes.
On this very volume. This is their manual only. 10.2.7. Deduplication campaign to remove duplicate entries in the electoral roll. In order to find out cognizable number of multiple entries in the electoral roll, a software tool based on SQL server has been developed and given to all chief electoral officers. The data should be pooled for deduplication in across border state boundaries and also between urban and rural areas near big cities, metropolitan towns. Deletion of probable multiple duplicate entries found by deduplication software shall be deleted after due verification by booth level officers and by following due process of law. If the name actually happens to be doubly appearing, then the person's name should be retained only on one location where he is ordinarily residing and deleted from the other location. And thereafter, my lord, again, page 201. Huh? Yeah. In fact, my lord, para 9.11 at page 201, after about 6 lines, after 5 lines, before every revision, para 9.11, page 201.
That you have reproduced in your brief note also.
Yes, it says, before every revision, the EROs are required to run deduplication software and remove multiple entries found and verified in the electoral rolls. So their own manual requires them to run deduplication software, etc. And now your lordship will see this ERO net, which is also part of the note also, my lord, and it is also there in this same page 310. 310. I mean, again and again, the manual emphasizes the need to run deduplication software. ERONet, they say ERONet has been created to provide a platform to EROs and other officials under them to process claims and objections, receive online, offline. It's a complete and foolproof network of all officials of the election machinery and the election commission to the chief electoral officers, etc., all over the country for close monitoring of the enrollment process, etc. Then your lordship may see 20.2.2 at the bottom of this page, maintenance of electoral rolls, and 6, Roman 6, removal of demographically similar entries, discrepancies in epics, and photographically similar entries. And then, my lord, your lordship may also see page 316, where they have said, provided for the procedure for removal of demographically similar entries and photographically similar entries. Para 20.5.4. So there can be duplication can be found, my lord, by seeing name, father's name, address is the same, or seeing that photograph is the same. So they have provided details of how it has to be done. It says demographically similar entries, procedure for removal, demographically similar entries. DSEs are thrown by software based on electors' demographic details such as name, relations, type, gender, date of birth, age, and address. ERO shall log in and do tabletop verification, etc. So great detail as to how to detect demographically similar entries, how to detect photographically similar entries, and thereafter follow the procedure for removal. You will go and field verify as to who is this person. Now, my lord, what happened in this case was, there are actually, unfortunately, in Bihar, if your lordship sees, very large number of people whose entries have been, duplicate entries have been left in the list. If your lordship sees the compilation that we have just handed over at page 46, these are in Bihar, in the current.
46 of which
but I'll give your lordship a table which was annexed by Mr. Yogendra Yadav in his affidavit. If your lordship sees the affidavit of Mr. Yogendra Yadav, the rejoinder affidavit, which is filed on which November? Some November, my lord. The
29th October 2025.
No, it's filed on November actually. Early November it is filed. This is the rejoinder affidavit.
Are you referring this one?
This is, of course, what we have just given to your lordship. These are all almost identical entries which are there in the final electoral roll. So it is not one, not two. But I wanted to show your lordship how many there are from total, how many there are from this Mr. Yogendra Yadav's rejoinder affidavit, who has given the summary what has happened. Anyway, my lord, your lordship may let me not spend time, but I am pointing out that in his rejoinder affidavit either dated 29th October or 1st November or something.
You can just read out.
3rd November. So what I am showing is, my lord, that he had given very large number of examples, and my lord, he has pointed out that after running the deduplication software, because what we can do is, we can convert, it takes a long time, lot of effort to convert non-machine readable voters list into a machine readable voters list. And then, my lord, one can run a deduplication software on that. Some people did that after spending a lot of computer resources, lot of effort to do that. And when that was run, it was found that in the August 2025 rolls, which is the draft rolls, there were 4,90,000 duplicate entries within the same assembly constituency and total 59 lakh duplicate entries across different assembly constituencies. And in the final roll, that number increased from the draft roll to the final roll. Has your lordship got that? Isme aap just turn to page 23. 23 is that table at the top, duplication.
Collecting those photocopies of the iCard or something.
Yes, and those are identical, different epic numbers. But photo is identical, names are identical, etc. And these have got in the Bihar final roll despite this special intensive revision. And this has happened precisely for the reason, and it increased. If your lordship see, all the numbers increased. All the duplicates increased from the draft August 25 roll till the final roll, all the numbers increased. Thereafter, my lord, next bulk electors. Now on bulk electors, the Election Commission has a rule which says that if there are more than 10 people in the same residence, same address, then the job there can be, but you have to go and verify. You have to go and check whether it's in fact those people are residing there. And now in some places it is found that there are 500 people at the same residence. Then people with whose address is given as 0, the numbers are more than 5 lakhs. 5 lakhs whose address is given as 0. So therefore, now if this had been given to people in a machine readable form earlier, etc., people would have...
You will have to, these factual aspects you will have to respond. Keep your records also ready.
So in this, my lord, Mr. Yogendra Yadav has pointed out, in this he has given examples of not just absolutely identical, photographically identical, demographically identical, same name, same father's name, etc. Few examples he has given, but the total numbers he has given are in lakhs, which remained in the final electoral roll. And about the number of people who are more than 10 people at the same residence, that is in crores, which should have been verified physically by door-to-door verification.
So let me continue after lunch, Mr.
All right.
We have 2 minutes from... Any solution, Mr. Diwan?
Come.
No. So I will, rather than get into the submission, though I have those, I am just suggesting a way forward. Because as we projected yesterday, we were very keen on the dates. So I'm suggesting, let them by 5 p.m. today, let us know some venue. Obviously, it can't be at some exotic location or something.
That's fair.
So I'm just suggesting, without prejudice to rights and contentions, by 5 p.m. because people have to travel internationally, Manoj. It's not easy. Some people may need visas also to come here. So till 5 p.m., please put an embargo. Let them suggest and make their arrangements and tie-ups, number one. They must obviously do the payment and the bookings, etc. for whatever venue which they book.
That we have indicated that.
Yes. So let it be. I think it should be in Delhi. I'm just talking from the standpoint of international connectivity. Because if they find some location in some other place which doesn't have that degree of international connectivity, it may become a problem. So I'm suggesting that. But if they get someone in Hyderabad, fair enough. I mean, I'm not going to complain. But there should be a hard line of 5 p.m. today. We are leaving it entirely to them. They will make all the arrangements, etc.
But Europe, as such, Hyderabad, there is also very good connectivity.
Sorry?
All these
No, I'm not saying that I don't know about these things. I'm just suggesting to the court. I have no problem with Hyderabad. Let me just make it clear. We are trying to have a workable solution here. But 5 p.m., they make the payments. Then as far as those reimbursements, etc. on costs.
Can take you.
All right. Fair enough. But also, I think if they don't get a firm venue by 5 p.m. today, then I think the SLP should stand dismissed. Because it can't then be, my lords, that people internationally can't travel, etc. They have to make some firm arrangement by that time, because it's going to be hugely disruptive.
You make the arrangements quickly and report us either 2 p.m. or tomorrow morning.
Plus tomorrow morning will again, by the time people,
But ideally, just because you have to just maybe some senior officer, some responsible officer you put on the job, he will find out and book it and inform.
Post it after lunch, my lord.
No problem.
We will take up at 2 p.m. immediately, but this 1 hour is meant to complete the exercise and come out with a
In fact, your
solution.
Lordship had suggested that at earlier, Lord, the first round, that let them go and find out from Lord ITC here, Maurya, Lord. I don't
Yes,
know
probably they were indicating that they have made some booking for themselves. They can hand over to that to you. They can book their own alternate somewhere else.
Because I want to also, because this is a very important issue. So we are trying to find a solution, but we have drafted very short points of submission without a counter, without a notice. So I'll just request that they take it on, your Lordship just take it on record, because these are important points. Just, I suggest that your Lordship don't look at it now, because
With your intervention, there will be a solution. Please find out a solution.
that's what we have said, 5 p.m. today should sound like a...
I think both sides are very reasonable and fair in that way. Tell Mr. Mehta to be here 2 p.m. and meanwhile you will do the exercise by 5 p.m. or so. Half an hour here and there, we understand, but you must give a confirmation to them that this is the arrangement made to their satisfaction, and morning then you will file a compliance affidavit.
May I just, Mr. Mehta, I know is on his legs, because I found myself in that difficulty yesterday. So 2 p.m., I don't know, he may still be continuing. Would your Lordship like to take it a little later, say 2:30 or so?
We can take you on 3 o'clock?
Yes, all right, 3 o'clock. I think it'll be safer.
3 o'clock?
Okay, 3 o'clock. We'll be here at 3. Someone will be on our behalf be here. Let's try and have a solution by 3.
3 o'clock, then even if you are hearing some other matter, we'll give a break for 5 minutes and we will accommodate you. We'll take up at 3 o'clock.
Grateful.
That bar council matter, I understand this is going on. But item 11, that's reservation for the bar council, because we have the election scheduled. So it will not terminate.
Next week, Tuesday.
But if tomorrow, it may be 5 minutes something. Workable solution can be.
What is the date of election? So that schedule that we have laid down. Mr. Guru, do something.
Maybe after this matter today.
I had
Notify the reservation by tomorrow. Make the matter infructuous on Monday.
Left to myself, I would have been happy to do it. There's only one.
They will all do. They are very progressive thinkers.
I know, my lord. They want to, but only one thing, my lord. Just one.
Maybe a quota fix for representation.
It's like this.
Some of these states, there might be some practical difficulty where nominations, etc. are there.
That's correct.
We will see that part. First, where there is no difficulty, you do it. You do it tomorrow during daytime, and we will place the.
I wanted to say 2-3 things, my lords. One, I'll just take 2 minutes. They are for it, my lords. But one thing, there is an issue of doing it for this election, my lords. My friend will bear me out for a minute. There are problems, my lords. In fact, my friends are putting it on 3.2 of the Act, which is proportional representation.
Mr. Guru Kumar, we want their visibility in this election also.
I understand.
But that's all.
I understand. But there are issues, my lords. Let's do one thing.
Where the issue we will try to resolve, and in any case, it should not be taken as an adversarial litigation.
No, I understand. There's only one issue, my lords. There are states where elections have already been notified. We can't have a situation, my lords, where in some places there is some provision made, in other places provision is
made. You segregate those cases where the election schedule is not only notified,
yes,
nominations have been filed. Just keep 1 or 2 states like that separately. But rest of the states, there should not be any difficulty.
There's another difficulty, my lords. I'll tell my lords why. This necessarily involves consideration. One is, according to us, my lords, as a matter of law, I'm submitting. Amendments of the act will be required.
No. Amendment of the act is not required. It's only the rules. And it's
no, even the rule
can always be read in the.
I'm only saying we are all for it. But only thing is, given all these legal ponderables and issues, my lords, and the time frame and the fact that some states bar council already the election process has started. For doing it in one place, not doing it in two other places, doing it in a third place, not doing it in the fifth place, it's fraught with difficulties. Would my lords consider this?
So we have heard one senior counsel for the parties very briefly, keeping in view the constitutional ethos, the recent legislative moves, and the orders passed by this court from time to time, we expect that Bar Council of India will construe the existing rules framework in such a manner that will ensure 30% reservation, occupation of 30% seats in each state bar council by the women members.
Can I make one?
Women members. Similarly, such an initiative shall also include some of the post of the office bearers also. Let the complete details be furnished by the Bar Council of India on Monday. It is clarified that the relevant rules shall be deemed to have been amended, providing provisions for making a provision for such litigation.
Just one request I wanted to make.
That will help you now.
No,
when that part goes.
It will strengthen my hand, but practically, my lord, there are two things. My lords have indicated 30% and office bearers. I'm only saying for the time being, please don't.
That includes.
No, I'm saying please don't say anything on percentages, my lords. Provision for reservation, if my lords can indicate. We'll find out what best can be done.
Mr. Kumar, we can't pass inconsistent orders.
No, I'm only saying this, my lords. I'm only saying even in some bar associations.
30%. Supreme Court bar 30%. Bangalore.
No, I know, my lords. There's only one fundamental difference. There's one fundamental difference. Number of people available, let's say Northeast, for example, my lords, we don't know how many women lawyers are there. How many will be able to really come forward, even contest? I'm only saying this, my lords. Please consider this. Please say, Bar Council will come back with submissions on the provision of reservation, my lords. Please don't indicate anything.
No, we don't want any lip service from you.
This 30%.
Kohima High Court, there are women lawyers. I was there just last week.
No. I'm saying, my lords, this is.
We wish that you were there yesterday's the workshop. We will not say conference. It was a workshop because they have done a commendable job. They have done a commendable job. They distributed a form. Sought opinion from all the members of the bar and from different places. 83% women members want to be office bearers in the Bar Council and Bar Association.
Yes.
Look at their enthusiasm. If that is so, you should also and we should also take.
No, that's true. All I'm saying is this, my lords, this indication of percentage for the time being. I'm only saying that, my lords. My lords may say
30% out of 100.
No, in fact, my lords, one thing, just one more minute, my lord, I'm sorry, just at the break of lunch. The famous US Supreme Court Judge, Ruth Bader Ginsburg, was asked, how many will be enough for US Supreme Court by way of women representation? She said all 9. But she also said, change and enduring change can take place only when it is done over a period of time.
That part we are not commenting today.
Therefore, my lord can consider this aspect, my lord. We'll come back with what can be done.
Mr. Guru Krishna Kumar, see, when we introduced the equality clause in 15 in our constitution and when the other jurisdictions brought it, that effectively answer your question.
No, I understand.
So our commitment is right from the day we got a constitutional democracy.
That is true, my lord. In fact, that's one of the things I was highlighting. We need to have some legislation and change, my lord.
Please know something. We know that initially it will cause some teething problems, some
issues are there. Some places it's practically impossible. That's why I'm saying, my lords. My lords, at the time being, may not mention about the percentages and office bearers.
It's a continuous mandamus. We will resolve wherever the issues will come. On Monday, you come out with a notification.
Very well, my lord. We'll come back with what.
When it comes to 30%, we'll make sure they are there.
All right, we are coming up.
Item 29 on the same issues. Item 29.
We have passed a general order. Yes. Then it will apply to everyone.
29 now.
All right.
Yes.